Welcome to today's Explainer, KSLU Law students. I'm your professor for this session, and today we're diving straight into a highly focused, strict academic breakdown of Muslim personal law. Specifically, we're looking at marriage, or Nikah. Now, listen carefully, because our clear, undivided goal for the next few minutes is to make absolutely sure you know exactly how to score maximum marks on a 16-mark long-form question on this exact topic. We aren't just learning the bare text of the law today, we are learning how to present that law perfectly to your university evaluator. The structure we go over today is exactly what you need to replicate on your answer scripts, so let's get started. Here is our agenda. 1. Introduction and definition. 2. Essentials of valid nikah. 3. Valid marriage or Sahih. 4. Void marriage or Batil. 5. Irregular marriage or Fasid. And finally, 6. Exam conclusion strategy. Now, a quick tip. Meticulously draw up this exact table of contents as a synopsis on page 1 of your answer booklet. It's going to immediately impress the examiner before they've even read your first paragraph. Okay, heading number 1, Introduction and Definition, the foundation of nikah. When you open your exam answer, you've got to establish the jurisprudential nature of the topic right out of the gate. Under Muslim law, marriage is viewed fundamentally as a civil contract, but it's one that's beautifully combined with a deep religious element. It isn't merely a sacrament like you see in some other personal laws, it's fundamentally contractual. Now, to secure those top marks, you must cite authoritative jurists. We're going to use Mullah. Mullah's definition of marriage states, marriage is a contract which has for its object the procreation and legalization of children. I want you to read that again and memorize it word for word. In your exam booklet, write this out and strictly underline the words procreation and legalization. This specific phrasing is exactly what the evaluator is scanning your paper for. It perfectly encapsulates the dual purpose of the nikah, fulfilling a contractual obligation and ensuring social and legal order for future generations. Let's move on to our second heading, Essentials of Valid Nikah, the 6 core conditions. I need you to transition your focus and pay strict attention here. This enumeration forms the heavy, mark-fetching bulk of your 16-mark answer. If you miss a condition, you lose marks. It really is a simple equation. First, proposal, or Ijab and acceptance, Qubool, which absolutely must take place in the exact same meeting. Second, competency of the parties. They must be a major, and remember, puberty is legally presumed at 15 years of age here, and they must be of sound mind. Third, free consent. This means it must not be obtained by force, fraud, or coercion. Fourth, Dower, or Mehr, which acts as the legal consideration for the marriage contract, and keep in mind this can be prompt or deferred. Fifth, no legal disability, meaning parties must not fall within prohibited degrees of relationship or unlawful marriages like polyandry. And sixth, witnesses. Now when you write this in your KSLU exam, list them as distinct unmerged bullet points exactly like this. Do not write a messy, rambling paragraph. Use crisp, clear bullets. So let's dissect a really crucial nuance regarding that 6th point, witnesses. Sunni law requires 2 male witnesses, or 1 male and 2 female witnesses, whereas Shia law considers witnesses not essential to the validity of the marriage at the actual time of the contract. Highlighting this exact difference is going to show tremendous academic depth to the examiner. It proves to them that you aren't just memorizing a list, you're actually comprehending the varying schools of thought within Muslim personal law. Right, we now move to the legal classifications of marriage. Section 3, Valid Marriage or Sahih, subtitle, Fulfillment of Essentials. This is the baseline, folks, the perfectly valid union against which all other classifications are measured. In a Sahih marriage, all the essential conditions we just discussed are completely fulfilled, and the legal effects? They are immediate and they are binding. It establishes the legitimacy of children, creates mutual rights of inheritance between the spouses, and establishes the wife's right to maintenance. Make sure you deliberate on this in your exam. These full legal effects are the guaranteed, legally enforceable results of a Sahih union. Okay, pause deliberately right here. We have our very first mandatory case law breakdown, Abdul Qadir versus Salima. In your answer script, I want you to explicitly draw a distinct, neat, rectangular box around this case name. That immediately captures the evaluator's attention for a 16-mark answer. So what's the factual matrix? The brief background of this landmark case revolves around a wife's claim for her dower before the consummation of the marriage. The final ratio dissidenti, the binding verdict of the court, firmly established that a Muslim marriage is fundamentally a civil contract. Now, what's the absolute relevance here? Why does this matter? It matters because it cements the legal concept that the rights and obligations of marriage, such as the dower or mehr, are governed by the strict terms of contract law, not just purely as a religious sacrament. This case is your absolute anchor. Do not forget it. Transitioning to heading number 4, void marriage, legally termed Batil, subtitle, void ab initio. When you write this specific section, you've got to dictate to the examiner that Batil is the exact polar opposite of Sahih. It is a marriage that is fundamentally flawed at its very core. A Batil marriage is void right from the beginning, and that, of course, is what void ab initio means. Crucially, emphasize on your paper that a Batil union yields absolutely zero legal standings for either party. It produces absolutely no legal rights, no legitimacy for children, and no inheritance rights whatsoever. And you must provide exact examples to secure those marks. Example 1, marriage within a prohibited degree of relationship. Example 2, marriage with a married woman, which is polyandry. These are absolute bars, rendering the contract completely null. Moving to heading 5, irregular marriage, or Fasid. Subtitle, defective but curable. Now we introduce the absolute trickiest concept of today's explainer. I am warning the classroom right now. KSLU evaluators heavily scrutinize a student's grasp of this specific section. Many students confuse Batil and Fasid, but you will not. Let's dissect exactly how a Fasid marriage uniquely differs from a Batil one. The marriage is defective, yes, but fundamentally, it is not void. Why is that? Because the defect is temporary, and it can be formally validated by removing the defect. This legal mechanism of curing is vital to understand. For example, a marriage without witnesses in Sunni law is merely irregular. Add the witnesses and boom, the defect is cured. A marriage with a fifth wife, if the man divorces one of his previous 4 wives, the impediment is removed. A marriage during the Iddah period, once that Iddah period expires, the marriage can become regular. The legal effects of a Fasid marriage are highly specific, and they're completely dependent on a single event, consummation. Before consummation, there are absolutely no rights, no maintenance, no inheritance. But after consummation, the most crucial shift occurs. The children born of this irregular union are considered legally legitimate. Note this structural comparison well, guys. Writing a clean before and after breakdown like this is a classic, high-scoring exam format that evaluators actively look for. It's time for our second deep case law breakdown, Atta Muhammad versus Cycle BB. Direct your pen to explicitly underline this case name and its ratio decidendi right on your paper. This case recognized the validity and the legal consequences of irregular marriages, specifically after consummation. The factual matrix involved complex disputes over inheritance and legitimacy, all stemming from an initially defective marriage. The court's final verdict ruled that once consummated, a Fasid marriage actually affords legitimacy to the offspring. The absolute relevance of this case is that it perfectly demonstrates the law's protective nature toward children. It tells the examiner you understand the deep social policy embedded within Muslim personal law, that the law strongly prefers to cure a defect rather than brand a child illegitimate. We now shift to the final portion of our lecture. Heading 6, Exam Conclusion Strategy, finalizing the answer script. Listen, how you end your answer is just as important as how you begin it. You must wrap up your 16-mark essay with undeniable academic authority. Do not just let the answer trail off. I've drafted the perfect conclusion for you. Muslim marriage is a contractual relationship governed by conditions. Its classification determines rights and ensures legal clarity and social order. Write this out verbatim. This neatly synthesizes the contract elements you discussed at the very beginning with the broader societal objectives and classifications you detailed in the body. It brings the entire 16-mark essay full circle, leaving the evaluator completely satisfied with your comprehensive legal reasoning. I'm going to conclude today's academic session with this provocative, exam-focused question for you to ponder. On your exam paper, can you flawlessly articulate how the curable nature of a Fasid marriage maintains social order compared to a Batil union? Challenge yourselves to really internalize this core legal distinction, because if you can answer that question affirmatively, you are fully prepared to secure top marks. Review your notes, practice your formatting, and best of luck on your KSLU examinations. Class dismissed.